And next, may we have Christopher Alvarez?
Be right up.
Because number 2021-0D0-1337 and 2021-0D0-0772 and 2022-0D0-0253 and 2022-0D0-0792, State of Texas versus Christopher Ray Alvarez. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Alvarez, we're ready.
And Mr. Alvarez is appearing from the jail annex. We are scheduled for a final hearing plea deadline in all of these cases, although I think some of them were actually set in the morning. We're scheduling wise a little bit different on this case because I kept thinking because we had it set for final hearing plea deadline that trial was this Friday, but it's actually next Friday. And so one thing I wanted to confirm with you all is that when I was looking at the panels for next week, we are actually not in commissioner's court next week. And so I am just giving you the heads up that we are scheduled for the courtroom on both days. Okay. So I will try, but I saw a couple of special settings in other courts, but just know I will try and get us commissioner's court instead of having to do this. Just right now we're in the courtroom. So be prepared for what is sometimes a headache of multiple panels like that. But in any event, what's the rec, Ms. Elizalde?
Judge, if you recall, the rec was pulled. The probation rec was pulled and it is now a trial case.
Okay. So what's outstanding?
There are two things that, is it okay if I go first, Mr. Huffman?
Yes, ma'am.
Okay. The first thing, Judge, is CPS records. I've already had a conversation with Mr. Huffman about this. The court may recall that we have been trying to get CPS records for some time now. Original request originating back in April. We received 840 pages, which you signed a protective order on, and we received 36 pages, additional pages with no affidavit, which means we could not get a protective order on that. So I have made a special arrangement for Mr. Huffman to come and view those in our office. However, today, because we've been asking for an affidavit for so long, we received a follow-up from CPS saying that they were still working on our request and it was expected to be completed July 28th. I have discussed this with Mr. Huffman. The state has, and we show the court that the state has been diligent in obtaining these things. We don't believe that this will slow the trial down, but it is I don't want this to have any Brady issues. I want it to be on the record that I've been disclosing all of this and that Mr. Huffman is saying we're going forward anyway.
Okay. So, Mr. Huffman, is that accurate?
It is, Judge. And I don't doubt that they just got the CPS records. I am, I guess, scheduled to review those records. I think it was tomorrow.
Okay.
And
are these
so
specific? Let me ask. Are these specific to the 1337 case?
Yes, the ones. So the 36 ones are specific to the 1337, and then the request that is being processed is also specific to 1337. But
Okay.
Judge, I do want to put on the record, I don't know what that's going to come of it. I'm very confused by why we keep getting these piecemeal records from CPS. It's never happened like that to me before.
Okay.
yeah, and I guess Judge, if I guess I can get maybe the courtesy of knowing kind of if there are going to be specific records that are actually used in the trial, that would be helpful. I mean, I've got a bunch of, I said 845 pages plus the 36 pages plus I think there's some audio and recordings plus I mean I've got just hours and hours of jail calls, so they're kind of just giving me tons of discovery at last minute and saying, here you go, I may or may not use some of this stuff. It's just for me it seems a little unfair.
So in terms of the I mean, the only thing I'm understanding is somewhat last minute is the CPS documentation. Is there something else?
No, Judge, and I do want to say that obviously I haven't made any determinations, but the purpose of me giving this over is not say, hey, I'm going to use them. I just want to make sure I'm in compliance with Brady. That is all.
Yeah, well, I don't know, and that's the problem. I don't know if they are going to use them. They're just giving me a ton of stuff, and there may be the needle in the haystack that is going to come out and really hurt my case.
I mean, to answer that question, I would have to review all of those things just like you would. It's so hard to tell you right now that I'm not going to use them, but even if I did find something, I'd probably have to have live testimony rather than admitting the actual records. So I understand what you're saying, but it's so far-fetched, I think, at this point. And Judge, the real issue with this is these CPS records, I'm actually surprised we even got 840 pages. The victims and the defendant, they're not related. They're not spouses. They don't have children. I am very surprised that this is what we have.
Yeah, I could probably ask a lot of questions, but it's not really my business to know what you all are or how this, I mean, I can tell you that in drafting a proposed charge this weekend and yesterday, I did see there's 2 different complainants, obviously, and so I don't know much about your cases. I'm not hearing what else. Well, okay, well, let me ask what else. We've got last minute CPS records, voluminous and still to be completed.
Just other than that, the sole question the state had is, I just want to confirm that I'm going to have people take the stand on Monday. I know that Mr. Huffman is also sending out subpoenas, so to have them come, I'm not hearing that anyone isn't going to show up, of course, but should I have them all be here the first day of jury selection, or can we schedule them for Monday? What does the court want to do?
So, I mean, it depends how you're going to present them, right? I mean, you'd be ready to put on your evidence on Monday. How you proceed in that way, I mean, it's really hard for me to tell you. I mean, it's probably a very good idea to have them all here if you anticipate their, I mean, I'm not sure what you're asking. They should be here. If some are unavailable, but you're not calling them that day, so be it. I can assume folks are going to be under the rule.
What I meant, Judge, is opposing and Huffman, I'm not sure if you've already done this, but opposing counsel will send out their own subpoenas for the same witnesses. Like having them come in on Thursday, the day of jury selection. At least that's what happened last time. So am I to tell them to show up on Thursday for jury selection?
I mean, if they receive a subpoena from the defense to be here at a time different, for example, than what you're doing, then they're required to be there. It's an order. I mean, they're there under a different subpoena, not yours.
Okay, Judge, just confirming that they had to show up for jury selection.
So
that's it.
And I guess Zelda is trying to ask, like, when is evidence supposed to start? Is it gonna be Monday? Okay.
And I can assure you that will be the case. I mean, I feel comfortable as saying that if we have 4 individual panels, it definitely will be Monday.
Okay.
Okay. And Huffman, are you going to do it for jury selection or Monday? Are you okay with
Monday? Yeah.
Monday? Okay, good. So Judge, from the state, that's all we had to bring up. Otherwise, we are ready for trial.
Mr. Huffman?
And just for the record, Your Honor, I have not been given any CPS records as of today. I have, obviously spoken to Miss Elizalde this morning about the CPS records, but I haven't seen any. So those have not been disclosed as of yet.
So I understood that the 840 had been disclosed. Are those not?
The protective
No.
order was just signed off by you, Judge, today. So
Mhm.
those will be hand delivered. The 36 pages cannot be disclosed because we did
Right.
not receive the affidavit. And Mr. Huffman picked the time and date to see those, which will be.
Gotcha. Gotcha. Okay.
So obviously we'll be objecting to the admissibility of those records for the late disclosure.
Okay.
And that, I mean, I think at this point, that's all I have, Your Honor.
Okay. So with these issues, I am going to have another final hearing plea deadline on Tuesday. Okay. For an update from you guys. Do you want it at the jail docket or you want it in the early morning?
Whatever the court sees fit.
You want your client available or not, Mr. Humphrey?
Yes, Judge.
Okay, so we'll do 1 week from today at 3 p.m. and I'll get a further update from you all.
Okay,
Okay.
Judge.
All righty, thank you very much. Who's next?
Page 22, Judge. Annex, may we have Miller, Victor Miller?
Yes, sir.
All right. Please select English on the interpreter function. Thank you, Ms. Noyola.
In cause number 2022-0D03762. State of Texas versus Victor Manuel Miller. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
You're all right.
Mr. Huffman, I'm not hearing you, so please select English. Mr. Huffman, are you there?
I am, Your Honor. Judge, can you hear me? Your Honor, can you hear me?
I can hear you. I don't know why she can't.
I can't because I mute original audio.
Oh, okay.
There you go.
How am I
There you
on,
go.
Judge?
There you go.
Okay.
All right. And Mr. Miller is utilizing the assistance of a court interpreter, Ms. Gloria Noyola. Ms. Noyola, are we set up at the annex? Thank you very much. We're scheduled for a probation status. I have us down for a probation status hearing. Is that right?
Yes, Judge.
Oh, and I know I read the report, but I'm not seeing it at this moment. I do have a huge question though. Mr. Ruiz, why is it that we cannot have the screening done in the jail?
I'm not sure, Your Honor, but I was in contact with Aliviane today in the morning. They told me that he could be like admitted, but they need to be provided with the history of substance abuse from Mr. Miller, which we don't have any information. So they told me they could not have any, well, he cannot be admitted at this time since there's no history.
How is it? I mean, why are we proposing or entertaining? We've gone 2 times, right? The last time it was like a no-show when he's in custody and it seemed like it was just confusion. And so now we have him set again. So why is that not happening?
I'm not sure, Your Honor. The jail confirmed that they were gonna set up the appointment. I provided the phone number and the time of the appointment. They did confirm and everything, so I don't know what's going on their end. But my recommendation will be for him to be released, so that way he
I'm not gonna release him because the issue is this. The issue is he immediately started, and I understand you all don't have a history, but I believe he's admitted to use. You don't have him testing because he's not showing up for testing and he's causing problems at home. And so my only concession with Mr. Miller was to rather, and I understand you all or BHRTC is not accepting him for the same reason, but my only concession in looking at Aliviana was the fact that we could have him screened in jail, and we've really spent like 2 months trying to get that done. Makes absolutely no sense to me. And really it's like a waste of time. You know, what other recommendation do you have other than a release so that we can do what we have failed to do in the jail for 2 months?
I believe I could have him reassessed through TAP again, and we could go from there. If he qualifies, it will be through TAP, and then maybe he could go to, if I'm not mistaken, he has insurance, so he will be referred to Ozar.
Ms. Elizalde, do you have any input?
Well, Judge, considering that he's not reporting, I don't really trust that he should, do like an outpatient.
No,
Right.
no, I was never there at outpatient.
So the only thing I can think of is Safe P.
Mhm. Miss, or Mr. Reese or Miss Pineda, can you send me the most recent update? I know I read it. I don't know why I can't find it. Let me see. The last one I have is from July 10th. But I know I read the current one that showed the second failure to evaluate, I guess, lack of a better term. Mr. Huffman, you have anything for me?
Judge, we're Mr. Miller's, he's had a long time to sit around and think about his performance on probation. He's a young man. He has a good work history. He's got a place to live with his mother, who is okay with him coming home. He did, I would argue that he'd be placed on maybe a mental health caseload, and for that issue to be explored. But he's been in custody a long time, Judge, and he promises to comply with the conditions of probation,
Found it.
and we're asking the court to give him another shot.
No, I mean, so he can give mom the same headaches that he gave dad?
Judge, maybe the court would consider some ACOP days.
I mean, honestly, what I'm thinking is 2 TDC. This all starts because the initial assessment, the individual who did that assessment felt that he was not being forthcoming. In other words, he wasn't owning up to his use and all that type of stuff. And so then, we start making everybody, the jail, Aliviane, everyone else having to cater to Mr. Miller, who has found it, just kind of like whatevs, right? It doesn't really matter if he does or doesn't, if he's forthcoming with probation or not. All of that is indicating to me that he is not willing to perform the conditions of probation. So, I mean, I'm ready to revoke him.
There were some issues at the house, Judge. Mr. Miller does suffer from depression. I think with the right services and the right treatment, he will be successful on probation. I don't know if there are any other options, Your Honor. I'm trying to think.
Well, the recommendation from probation is that he be released, and that's out of the question. And everyone keeps relying on no history of substance use, but it's really because he just chose not to either show up for any type of testing or be forthcoming with the initial person who assessed him, right? He had a TAP assessment on June 1st, right? He met criteria for cannabis use disorder, but he is minimizing and withholding information regarding his use. So, I mean, I don't understand what would change Mr. Ruiz with another assessment, with another TAP assessment.
I think the court was gonna give Mr. Miller another opportunity to be forthcoming with the probation department and to try to seek treatment. And it wasn't his fault that they didn't interview him, Judge. He had tried, he placed a bunch of calls to the Oliviane from the jail, just nothing. But he's ready to get help and to be forthcoming. And we're hoping he gets the opportunity, Your Honor.
Your Honor, I could ask Aliviane to see if they could go to the jail and do the assessment like in person.
Isn't that what we've been trying to do, or no? It's been a phone call?
It's a phone call.
So how about we do this? How about we bring Mr. Miller on Thursday at 10 a.m. Mr. Ruiz, please coordinate with Aliviane to have someone here to do that assessment.
Okay, Your Honor.
All right. All righty. Thank you very much.
Thank you, Your Honor.
Who's next?
Bottom of page 21, Judge. And next, may we have Harris, Liliana?
Yes, sir.
Does anyone else need the interpreter?
I don't think so, Judge. It was just Miller.
Thank you, Ms. Noyola. Have a good day. All right.
In cause number 2022-0D04389, State of Texas versus Liliana Harris. Announcement of council, please.
Juliana Elizalde for the state. State is ready.
Carl Dakota for Liliana Harris, ready, Your Honor.
All right, again, we are set for a probation status hearing. We haven't even had an arraignment. She's been in custody for 40 days. Ms. Elizalde, do you have a rec in this case?
Yes, Judge. Originally, the rec was 6 deferred, and now because of her history on PR, I would like to add the component of BHRTC.
So is that is part of the rec?
Correct, Your Honor.
Okay, Mr. Dakota, I don't know if you'd received a rec on her before.
I was aware of a 6 deferred, but not the BHRTC part.
Okay, do we have a history, Ms. Elizalde? Is that what's going on?
Just a moment, Judge. I believe I was under the impression that it wasn't just reporting, but I might be thinking of something else. No, Judge, I don't think she has history. It's the nature of the charge.
Your Honor, on Harris, this is the one that's not probation.
Right, I understand. In fact, okay, there she is. Oh, she'd been removed from the docket, I see.
And she has possession of marijuana stuff, but nothing that got charged, Judge. And that goes back to 2021. And 2 in 2021.
Okay, did we already have a waiver of arraignment turned in this case?
No, ma'am.
Mr.
I'll get that
Dakota,
in, Your Honor.
please get your
I'll take
waiver.
care of
We have a status conference on August 22nd, 2023. Let me look back at a little bit of her history.
Sure.
I'm not sure, Ms. Elizalde, that I would be, unless there's a little bit more here. inclined to go straight to BHRTC right off the bat without some type of screening, but let me go back into is the PR violation, do we have any other cases coming up?
Judge, there is a note that says new case not indicted yet, but prior to this hearing, I looked it up and I couldn't find a new case.
Waiver of appointment, warrant. We'll come back on our August setting, Mr. Dakotes, if you'll get your waiver in. If I don't see some type of history or something more urgent, maybe Mr. Dakotes, you can discuss it with your client. I'm not necessarily inclined to go BHRTC. We can certainly screen her and see what services to apply to her case, but I'm not sure I'm going to go BHRTC unless I see something.
Yes, Your
So
Honor.
the rest of your settings are at the regular morning jail slot. I mean, the morning slot, not the jail slot. So thank you for appearing, Mr. Dakotes. Ms. Harris, your attorney's going to be in touch with you. The offer right now from the state is 6 years deferred probation. Okay. All righty. Thank you very much, Mr. Dakotes.
Thank you, Judge.
All right. Who's next?
Second on page 20, Judge. Annex, may we have Arnold?
Yes, sir.
Ms. Alvarado, are you covering this case?
Yes, Judge.
Okay, go ahead, Mr. Marufo.
In cause number 2022-0D01419, State of Texas versus Cyrus Jamal Arnold. Announcement of council, please.
Liana Elizalde for the state. State is ready.
Alexandra Alvarado with adult probation.
Mr. Huffman, are you on this case as well?
I am Judge. Rick Huffman Rick Huffman on behalf of Mr. Arnold, we are ready.
Mr. Arnold is appearing from the jail annex. We are scheduled for a probation status hearing. I did review the case summary. He terms in 2027. Reading a lot of the updates, the update with respect to his daughter, I guess is with grandpa at this point. Is that right, Ms. Alvarado?
Yes, Judge.
Okay. And then I guess the continued drug use. I'm really at either a revocation of 2 TDC. I'm not sure if there's outstanding restitution, Ms. Elizalde, that I did not see. I did not look into either that or Safe P.
Judge, I thought I had looked at the original terms and restitution wasn't included.
Okay.
But Carl, I don't know if probation can verify that because I was looking based off their summary.
To my
Is that-
knowledge, there's no restitution, but I can double check.
Yeah, it's unfortunate. I also saw a P file here. Let me see. No. Or maybe. Oh, that's on a resisting. So he has a resisting somewhere, misdemeanor world.
Yes, Judge, there's no restitution.
Okay. Let me go back to the case summary. Mr. Huffman, does your client want to get some treatment or does he want to just do his time and be done?
Your Honor, I spoke to Mr. Arnold, but I don't think I asked him that specific question. He actually, he wants to do what he needs to do to get out and be with his 13-year-old daughter. He had recently been given custody of that child, and from what I understand, that CPS case was a stressful process. I know Mr. Arnold suffers from bipolar and depression. He had a case with EHN, but I think that case was closed. He definitely does better with treatment, and he knows that and he understands that.
I'm very concerned
Yeah.
about this. I understand it, you know, there's a lot going on here, but my concern is he already completed BHRTC. And once outside of that type of environment, he starts using meth again. You know, he was still trying, I think, to, you know, maintain or salvage or whatever it is with his daughter. But what I'm seeing here is that, let's see, aside from his positives, that he no longer had his daughter residing with him and she was being cared for by grandfather. And then we have a new burglary of vehicle on June 15th. I just, you know, the next step in the treatment world for me is SafeP.
Your Honor, I would ask the court to take a look at that burglary of vehicle. It's my understanding that's not the strongest of cases against.
I don't want to
Mr. Arnold.
sound, I don't want to sound like not interested, but that is not my concern. My concern is his continued drug use. And, you know, the instability, once he is outside of an inpatient type of scenario, he just falls back into meth.
And I suspect it has something to do with him self-medicating, Your Honor, and
Sure.
but you know, if possible, we would ask the court to consider placing him on the mental health caseload.
Judge, if I may,
You may.
the way that the summary reads is he obtained custody of his child first. And then due to the substance use, not the CPS case, but due to the substance use, he lost her.
Right.
And if he can't get things together to keep his child, and I feel like we're at SafeP. That's what I wrote down, and I think that he has to work on himself in a
Right.
controlled environment.
I agree. I'm at SafeP, Mr. Huffman. This is not working, you know, it's not working. So, Ms. Alvarado, I do see the probation recommendation here is to continue to work with him in the aftercare and putting him on the family preservation caseload, but I don't think that's stringent enough for what's going on with Mr. Arnold.
Yes, Your Honor, and just so Mr. Huffman has like a more understanding of why we didn't go the mental health route. He didn't qualify for mental health services, so that way we can't place him there. And I do have to give Mr. Arnold some credit. When he came out and he was living with his grandfather, he was doing very well. It wasn't until he left his grandfather's house that he started doing not so well. And it just happened to be at the same time that everything happened with his daughter being removed. So he was trying really hard. I have to give him that credit. He was trying, but the drugs and the addiction is just a little bit bigger than Mr. Arnold thinks it is.
Yeah, I mean, it has to be because he went through BHRTC. You know, that's not nothing. That's not like easy treatment.
Yes.
This is very much of a problem. So I'm at SafeP, plain and simple. You know, I could tell you 2 TEZ, Mr. Huffman, but that's not going to solve his problem. He'll have the time and he'll get out and he's not going to have the structure. So that's where I am.
Your Honor, if we could have maybe a week.
Talk to your client. We'll come back in 3 weeks, 3 weeks for a pre-revo. Mr. Arnold, this is, I mean, you've been involved in the treatment. So the fact that you've had, unfortunately, these relapses really should be making the impression upon you that you need more help. And that's what I'm suggesting here. Your attorney can go into more of the details, but you know, I'm willing to work with you in that vein, but it's going to mean a much stricter course of treatment. Okay, so we'll come back in 3 weeks for a pre-revo. If your client is agreeable to Safe P, then we can just modify him into Safe P and go from there. Okay,
Okay, Your Honor.
thank you very much. Who's next?
On page 24,
Thank
Judge,
you, Ms. Alvarado. I'm sorry?
on page 24, annex, may we have Soto?
Yes, he'll be right out.
Does Mr. Soto need an interpreter?
No, Judge.
Okay. I have him, he was at 20,000, it got reduced to 5, so he's at 5,000 cash surety, is that right?
I'm not sure. I think,
Oh, we need a motion to revoke on Mr. Arnold?
Oh, yes, we do, Judge. We do need a
Okay.
motion. You did note it, and I am forwarding it to Mr. Vandenberg.
Thank you. Oh, it's so nice to have this.
Judge, I think this might be Mr. Munson's case.
I'm covering.
Oh, okay.
Call-
In cause number 2023-030-2964, State of Texas versus Nestor Daniel Soto. Announcement of council, please.
Ileana Elizalde covering for ADA Munson from BPU. State is ready.
Rick Huffman on behalf of Mr. Soto. We are ready.
And Mr. Soto is appearing from the jail annex. We are scheduled for a bond hearing. I show his bond at $5,000 cash surety. It was previously reduced in the jail magistrate from 20,000. It's been in custody probably over 90 days. Mr. Huffman, you may proceed.
Your Honor, I think we are waiting for plea papers. We had recently agreed to a probation offer in this case. It's 10 deferred, I think was the offer that we agreed to. And so we're just waiting on plea papers for that. Those were recently requested, but I just wanted to let the court know that that is what is going on. Your Honor, my client is 26 years old. He is a U.S. citizen. He's been in El Paso for about 5 months. He used to live in California. He lives here at 284 Amaria in Socorro with his cousin and his wife. I'm sorry, his cousin's wife. It's my understanding he's never been arrested. He has 3 children, and I think he's got 1 on the way. He sends them money. They live in Mexico.
Okay.
He works as in a warehouse, and he does house remodeling. Judge, he can't afford the bond right now, and we're respectfully requesting the court release Mr. Soto and granting a PR bond.
Ms. Elizalde, do you see, is that the rec in this case?
It is a probation rec, Judge.
Mhm.
And may I go now? Is Mr. Huffman?
Go ahead.
Okay, Judge, just really quickly, the facts, the defendant is a driver. He had 6 undocumented individuals inside the truck, including a 16-year-old. He admitted to picking them up and taking them to La Quinta. I have here bond is currently set at 5,000. Based on the probation recommendation made by Mr. Munson from BPU, he says he's not necessarily opposed to a reduction, but would like the court to note that we are requesting strict limitations on travel, if the court would so be inclined.
What I'm inclined to do is bring him in on Thursday so we can plea if there's an agreement. Because honestly, the bond to me, when I looked at it, it's reasonable. I understand if he doesn't have the resources, but primarily what I'm hearing is that your client is in agreement and ready to plead.
That's
So
correct.
if we had those, we could have done it today, but maybe that wasn't communicated. I am gonna set him for a in-person plea hearing on Thursday, 10:30.
Thank you, Your Honor.
Your request on the bond, though, is denied, okay? I
Yes,
want him
sir.
here at 10:30 on Thursday. Let Mr. Munson know, Ms. Elizalde, to get that paperwork going.
I will, Judge, and just to note, the last rec I have is 5 straight, underline 5. So I'm gonna make sure that Mr. Munson reaches out to him so they can clarify any discrepancies in negotiations.
Yeah, it was thrown out. It was offered at the last hearing and it was oral. So I don't know if Mr. Munson put it in the notes, but I've emailed Mr. Munson and requested the paperwork. So I'll kind of
Okay.
email him and kind of say that I think we're
We'll work
set
it
for
out on
Thursday.
Thursday. We'll get to the bottom of it, okay?
Okay.
See you on Thursday. Mr. Soto, we'll be bringing you in on Thursday for an in-person hearing, okay?
Great, thank you.
Thank you. Who's next?
Bottom of page 24, Judge. Annex, may we have terrazas?
Yes.
Alrighty, go ahead.
In cause number 2023-0D01848, State of Texas versus Jose Terrazas, announcement of council, please.
Eliana Elizalde for the state is ready.
Rick Huffman on behalf of Mr. Terrazas, ready.
And we are set for a bond hearing today. I think I had him, did I have him at 100,000? He was at 110. And then they split, they went down to 100, split it 50-50. Is that right? Does anybody know the bond?
I believe it is $100,000 surety. I'm not 100% though, Judge. I know it's over 75,000, and that's why we're here today, Judge. We're simply asking the courts to reduce it to something under 75,000. It's my understanding that the sheriff's department will not allow Mr. Sorry, Judge, I'm going blank here.
We're talking about trustee at a certain amount.
It is, Judge, and I think that threshold is 75,000, and we're simply requesting the bond be reduced to something under 75,000, so that my client can work.
The last thing I see is a 100,000 cash surety and then 10,000 PR.
I thought I had seen that this one had been reduced already from that 110 to 100, and it was split 50-50. Okay. What, are you done, Mr. Huffman?
I am, Your Honor.
Okay. Miss Elizalde, what number DWI is this?
Just a moment, Judge. Okay. So we have 1, 2, 3, 4, 5, and 1 dismissed. He is habitualized and the recommendation is 12 GDC.
What's the state's position on the bond reduction?
Opposed. We'd like the court to note that the BAC came back at a 0.215 and 0.20. There was a collision involved where he rear-ended someone. That person moved out of the way and he crashed into a train. The people that were the victims of the accident tried to get him out, but he refused, and the vehicle that he was driving was hit multiple times by the train.
Mr. Huffman, does he have any resources toward a bond?
No, Your Honor.
I'm gonna go ahead and, anything else, Ms. Elizalde?
No, Judge.
Do you know the amount, Mr. Huffman?
Anything under 75,000, Judge.
So I'm gonna reduce his bond to 100,000. 74,000 will be cash surety, 1,000 PR. Not operate a motor vehicle, monthly reporting, urine and breath analysis, monitor, curfew, subject to testing, all of those things. So 74, I'm sorry, I said 1,000, I mean 26,000, 26,000 PR. Alrighty, anything else?
No, Your Honor.
Thank you very much. Is there anyone else today?
No, Judge, that was